All right, welcome back, everyone. This is the third video in our Certificate of Merit series. In this session, we will be continuing our discussion with Nate, and we'll be covering the other 6 states. So in the last video, we covered 6 states and the requirements and the details of each one. And so we are following that up with the final 6.
Thank you, Adrian. And again, welcome back. Hope you're enjoying the informal but yet informative, look at certificates of merit. So let's dive back into the other 6 states. Now looking at Georgia. Georgia Code 9-11-9.1 requires that any malpractice lawsuit must include an expert affidavit with the original complaint, which is the initial pleading that is filed to initiate a civil lawsuit. And again, the affidavit must specify at least one negligent act or omission and the factual basis for each claim. Now, Georgia gives a little bit of a grace period if the statute of limitations is coming up. Every state has a statute of limitations for professional malpractice actions. Typically, it's 2, 3, 4, or 5 years after the alleged negligent act or omission, but that varies by state. But Georgia says that if the statute of limitations expires within 10 days of the filing of the complaint, the plaintiff may delay submitting the expert affidavit on the condition that an attorney must file an affidavit stating that the firm was retained 90 days or less before the limitations deadline.
Gotcha. So they kind of show that they're in process, that it's been recent, so they're and then there's a little bit of flexibility there in terms of the timing.
Yes. So for those of you who have professional malpractice claims in Georgia and you're running up against the statute of limitations, you want to take a look at that provision of the statute that gives you a little bit of leeway.
And just make sure you fit the criteria, as it sounds like, with having retained an expert.
Yes. So in Georgia, failure to file any affidavit with the complaint, or as I said, within that grace period, results in mandatory dismissal of the complaint. So Georgia's pretty strict. Going across the country now to Colorado. Colorado Revised Statute Section 13-20-602 requires a certificate of review, which again, we hear these terms and they're used interchangeably, but certificate of review, certificate of merit, affidavit of merit. And again, the certificate must declare that the attorney has consulted with a professional in that particular field, a professional that has expertise, that the expert has reviewed relevant facts. And for non-physicians, Colorado has a little bit of a exception here. For non-physicians, the expert must be competent through training, education, knowledge, and experience relevant to the alleged negligent conduct.
Okay.
Now you hear that and you would think that would be applicable to everybody. So for those of you in Colorado, that only applies for non-physicians. So if any of you Colorado lawyers can tell me why that's only for non-physicians, feel free to reach out to me, because that was a very interesting exception that I found.
Yeah, it sounds like there's just a little bit of flexibility with how you define expert in that state in terms of, for non-physicians. Obviously, it sounds like it gives a little bit of flexibility in terms of the disproving across, as you mentioned, training, education, and then knowledge that's where the expertise comes from. But that does sound like it leaves a little bit to make a case for that.
And in Colorado, again, mandatory dismissal of the complaint if the certificate isn't filed within the statutory deadline. So yeah, they're pretty strict on the requirement, as many other states are.
Okay, so it's very strict on the timing. Sounds like just a different structure in terms of looking at the expertise and that validation in terms of putting it together. Okay.
So going to California, California Code Section 411.35 is where you will find the rule for the certificate of merit. And in California, any plaintiff or cross-complainant suing for professional negligence must file the certificate of merit. There is a grace period. Again, just like with Georgia, if you're coming up on the statute of limitations, there's a 60-day extension after you file the complaint to serve the certificate. The requirements are pretty much the same as in every other state, that you've consulted with an expert, the expert is knowledgeable in that particular subject matter area, the expert believes that there's a reasonable factual basis for the claims that are being brought, and that the claims are not frivolous. In California, if you do not file that certificate of merit, it is grounds for a demurrer, which is a California way of saying a motion to dismiss or a motion to strike, again, which could strike the complaint and basically dismiss the suit. The identity of the consulted expert in California is privileged, and it's generally protected at this stage, which is interesting. But of course, as the case goes on, as lawyers know, gets closer to summary judgment or trial, you will have to disclose your expert. In cases where there are multiple defendants, sometimes lawyers ask whether or not you need to do or have a separate certificate for each defendant, because factually the claims may be different depending on the defendant. So in California, they only require one certificate, even if you have multiple defendants in your case. Now in Arizona, Section 12-2601 is the statutory reference for the certificate of merit, and it applies to claims against licensed professionals. Now, Arizona, is an interesting state with this statute because they specifically say licensed professional. Some of the other state statutes don't mention licensed professional. So it's interesting.
Like a more of a formal requirement than the proving that there's a level of expertise, as we kind of talked about for a couple of the other states.
And so in Arizona, when filing the complaint, the plaintiff must certify whether expert testimony is necessary to prove the licensed professional's standard of care. And then if it is, determined by the plaintiff that expert testimony is necessary, they must file a preliminary expert opinion affidavit pretty early in the case with their initial disclosures.
Okay. So it's definitely something that it sounds like there's kind of a step before some of the other states in terms of determining whether you would need an expert, whereas the other ones, it's just part of the process, or, whether it's beforehand or the flexibility of afterwards. But that is really interesting that they that there is sort of that check before you bring in an expert testimony.
And in Arizona, the affidavit does not have to be filed with the complaint, but it has to be served with what's known as the Rule 26 initial disclosures, which typically happens within 40 days of the defendant filing an answer.
Okay. So they let them know it's happening, and they know that sort of the timeline of when it would have to be in by. Okay.
Right. And in Arizona, if this requirement is not met, the complaint will be dismissed without prejudice.
Okay.
So they give a little bit of leeway there. Coming back to the Eastern Seaboard, South Carolina, Section 15-36-100 applies to any civil action for professional negligence against licensed professionals. The certificate is required to be filed with the complaint. Must file a certificate of, quote, expert witness as an attachment to the complaint.
Okay.
So South Carolina is pretty strict on the timing of when the certificate has to be filed. The requirements are pretty much the same as in the other states we've talked about, that the expert is qualified, the expert has the experience, training, and education in that particular subject matter, that upon review of the facts and claims, that the expert, in the expert's opinion, believes that the claims and facts have merit and that the claims are not frivolous.
Yeah, so I mean, it's very straightforward in that case. It sounds like there's no flexibility. That's just what you turn in when you're filing the complaint. It just has to be part of it. Okay.
It has to be part of it. And South Carolina is pretty strict on if a plaintiff's attorney fails to file, the complaint must be dismissed with prejudice.
So it's a non-starter. So we're not only you have to have it right at the beginning, but if you don't, that's it for the the process. Okay. They seem to be a little more rigid than some of the other states.
And looking at our last state, which is the great state of Texas, the Civil Practice Code, section 150.001, applies to claims arising out of the provision of professional services. So every state kind of defines licensed professional a little bit differently. So in Texas, it's claims arising out of the provision of professional services. And this requirement of the certificate of merit, again, the contents of the certificate are pretty much the same. That the expert practices in the same field, has the subject matter knowledge, and the expert is not a party to the case. That's sort of a given, I guess, in terms of conflict of interest.
No conflict of interest, even though they're in the same industry.
But yeah, there must not be any conflicts. And in Texas, they have a similar flexibility in terms of timing and the statute of limitations. In Texas, it says that if the limitations period is about to expire, and if insufficient time exists to obtain the affidavit or certificate of merit, the court may allow the plaintiff to file it within 30 days after filing the complaint. Now, take note of the word may. That means it is in the court's discretion on whether or not to grant the 30 days extension, basically.
The court would look at each case and decide if there was a reasonable amount of time, and then would sort of may, like you're mentioning, may grant that extra time, but it's not sort of just tacked on in terms of like a definitive. Okay.
Right. It's not an automatic. Lawyers will know all about, seeking what's known as leave of court, basically asking the court's permission for that extension of time. But provided that good cause is shown and it's made in good faith, I can imagine that most courts would probably grant the extension.
Yeah, definitely. But that gray area does make for some interesting details. Like, sounds like there's some kind of small, what seemingly sounds like almost like synonyms of descriptions from different states, but in the legal profession, I have to assume that those could create opportunities or obstructions just because of the structure of them.
Sure. Yeah. So I know the last two videos we've gone kind of quick on, the very, very tip of the iceberg requirements and contents of certificates of merit, affidavits of merit, certificates of review, depending on what the state labels them as. But as I said, hopefully we, gave you a good starting point of where to look further for more information if you're a practicing attorney. In any event, if you're a party or litigant that is engaged in or thinking about being engaged in litigation against a licensed professional in those 12 states that we talked about, please do your research, know what exactly is required, not only of you, but also of your expert, because there are requirements as the statutes lay out for both the attorney and the expert.
Yeah, and that's been really interesting, just to of the 12 states to kind of hear what like you said, the sort of the top line requirements, and then it will be talking a little bit or more in depth about sort of each step of the process and just overall like what the repercussions would be in terms of the actions you take for each step, like in the breakdown in the next two videos.